But just to note that we do not work for the Office of the Privacy Commissioner. And so there may be some pārtai that are better addressed towards OPC than your presenters today. And maybe we'll reiterate that again at the end. But wow, we have some great numbers there, and that's really heartening to see. So tērā pē, mā kue e tīmata, tā tātou hui. Mo te ata nei. Tēnā rā koutou katoa, mā kue tuku karakia, hei whakapai tā tātou hui, i ngā atua o te pō whaiariki, turiki mai o mahara tipua, turiki mai o mahara whatukura, turiki mai o mahara atua o ngā rangi, kia puta te ira tāngata, ki te whai au, ki te ao mārama, tihei, mauri ora. Tuatahi ake, me mihi ki te ariki nui kwini ngā waihono i te pō, e noho ana ki te ahurewa tapu, a o na mātua tūpuna, me te whare kāhui ariki, pai mārire ki a rātou, ki ngā mate huhua o te wā, ki ngā rangatira Mōrehu McDonald, Fred Graham, Tāmati Cairns, me e rā atu mate no ngā haue whā, haere atu rā ki tua o Pairau, oki atu rā. Ka hoki mai ki ngā ki a tātou, te hunga ora i takatū ana nei i te mata o te whenua, kei ngā maunga whakahi, kei ngā aua koi ora, nau mai, haere mai, he uri tēnei no ngā te tipa, ngā te māhanga, ngā te kino haku, te o Māori, ko Tahu Kukutai tōku ingoa, nō reira tēnā rā tātou katoa. Well, greetings to you all. My name is Tahu Kukutai, and I'm really delighted to be one of the first cabs off the rank, to use a really overused metaphor for Privacy Week 2025 webinar series. Ngā mihi nui to Michael Webster and the team at OPC for inviting us along today to be part of this series. So I wanted to start by acknowledging some of our recent losses in Te Ao Māori, and I particularly wanted to acknowledge our matua Tāmati Cairns, who was one of our cherished kaumātua on our tikanga and technology research program, who passed away on Friday. Moi mai rai te rangatira. So I'm coming to you from the glorious Waikato at the University Te Wharewananga o Waikato, Tingira Institute for Population Research, where I research issues relating to Māori population, Māori data sovereignty, Māori data governance, and more recently, Māori data privacy. And I'm also co-director of Ngā Pai o Te Maramatanga, which is Aotearoa's only Māori Centre of Research Excellence. So this is a bit of a tag team effort this afternoon with my colleague Jessie Porter, who is on the screen, waving, lurking in the corner. So Jessie will be talking specifically about collective ways of working under the Privacy Act 2020, and I'll leave it to Jessie to introduce himself properly when I tuku te rākau ki aia later on in our webinar. So I think I will share screen. Fingers crossed it works. It worked during our little trial, so here we go. Okay, that's looking pretty good. So, okay, so the kaupapa for our talk this afternoon is Māori data privacy, time to take it seriously. The title suggests that we think there's a bit of room for improvement, and I think there certainly is. It's a very timely kaupapa given Māori concerns over the use of facial recognition technologies while we're out buying our kai, doing our grocery shopping. The recent bankruptcy filing of the genetics testing company 23andMe, concerns over what's going to happen to people's most sensitive information, you know, not only about themselves, but information about their relatives, their whānau. And of course, there's a big kaupapa that OPC is leading out at the moment, which is the code to regulate the processing of biometric data here in Aotearoa. So there's lots going on to talk about. We only have like an hour today and we want to allow for questions. So we're going to do a light touch on some issues, a deeper dive in others, and try to give us something substantial to all talk about. But before we get into the specific issues, I just want to start by discussing some of the research that our team has been doing here at Te Wharewaranga o Waikato on Māori perspectives on data privacy, drawing from the Tikanga and Technology, or TINT, research program that's been funded by the Ministry of Business, Innovation and Employment. And I want to acknowledge the support and the wisdom and the guidance that we've had from our kahui kaumātua, who are shown here on this slide, and Matua Tamati Cairns, who's on the bottom, second from the right. And it's just me speaking today from the team, but there's a whole bunch of us, fine-looking folks. I don't have the time to go through and name all of us, but here's some of our researchers. You may recognise some from previous privacy weeks. Of course, Lanao Tawhurihuria, who's a Māori specialist in IP, and others on the screen, and then our kahui kaumātua as well, seated at the front. So why the heck does data privacy matter for Māori? Well, of course, it matters for all of us. It matters for all New Zealanders, but there are some specific considerations for us as Māori. We know from recent surveys from the Office of the Privacy Commissioner, and I believe there's another one coming out soon, that Māori are more concerned about privacy in pretty much every way. Māori are more likely to be concerned about individual privacy, the protection of personal information, more likely to see the privacy of Tamariki as a major concern, and more concerned about FRT and government sharing data. So there's some real concerns out there in Te Ao Māori about this kaupapa and a real appetite to be engaged in it and to have a say. Of course, as Māori, we have collective lived experience of state surveillance. There's a recent of course, report from Police Complaints Authority and OPC on the unlawful photographing of rangatahi Māori. We have the Tūhoe experience. There's any number of examples that we could talk about around state surveillance. So there's a very keen sense of that within Te Ao Māori. We know that privacy risks are increasing with surveillance technologies, and other speakers throughout the webinar series will be talking about them specifically. And of course, let's not forget that privacy is a fundamental human right and a gateway right that reinforces other rights, such as the right to discrimination. So it's a kaupapa which radiates outwards and has impacts in other aspects of our lives. So I'm going to have a really brief high-level overview of, I'm getting ahead of myself, of our Māori data privacy framework research. So, as most of you will know, data privacy laws in most countries focus on the protection of personal data and personal data privacy. However, the sort of Western emphasis on individualism really contrasts with other traditions that see humans as relational beings whose identities and lifeways depend on their relationships with others and their environments. And this relational paradigm, which is intrinsic to Indigenous cultures, has implications for how we think about data and how we think about data privacy. So when our team at Waikato began developing the Māori Data Privacy Framework as part of our research project, we were really interested to see if we could identify some shared features of Indigenous concepts of privacy. And what we found was this, that Indigenous concepts of privacy are inherently collective, and they're underpinned by Indigenous laws and protocols that determine when, how, and by whom information and knowledge can or should be shared. That Indigenous collectives assert that they have the right to own, control, steward, care for information collectively, in much the same way that an individual owns and controls her personal information. That where an individual's information is intermingled with others, and an obvious example of this is genealogical and genetic data, that there is a collective privacy right, and that recognising and upholding relationships of belonging and responsibility and respect are really paramount. So for Indigenous peoples, the protection of personal data is just one part of a much wider set of privacy considerations. And I would also note here that the Special Rapporteur on the right to privacy has endorsed Indigenous data rights in several reports, and has also called on governments and corporations to recognise, the inherent sovereignty that Indigenous peoples have over their own data that comes from them, or that is collected from them, or that is about them. So in recent years, Indigenous groups have developed their own data protection technologies, to really try and push back against, for want of a better phrase, data colonialism, and to try and give their communities some semblance of control over information about them or that comes from them. There was a really interesting 2023 article in Scientific American that discussed some of these initiatives, including some communities here in Aotearoa, and I also wrote about some of these initiatives in a piece for Science magazine last year, which generated a lot of interest. And I think the interest is that not that data colonialism or some of these challenges are new per se, but there's wider interests, including outside of Indigenous communities, and the innovative ways that Indigenous communities and peoples and researchers are conceptualizing and responding to privacy challenges, and what might be the implications for others. And I found this as well when I attended the IAPP in Washington, DC a couple of weeks ago, and we had our first ever Indigenous privacy panel there. And there was a huge amount of interest really in, how do these Indigenous perspectives on privacy, how do they differ from mainstream concepts of privacy, and what might we actually learn? And there was particular interest in the collective dimensions of privacy, and it's really great that Jess is going to be able to talk to that a little bit later, specifically in the context of the Privacy Act. So I'll just give a brief overview of the high-level elements of this data privacy framework that we've been working on in our team. And we've been hoping to, just finishing the design elements of it, and then we'll be publishing it very shortly on our Te Ngeta website. The design is from Nikki Kennedy from Tapu, and you can see we have a whakatauki here, which came from our kaumātua, guided us in this regard. And it's a very well-known whakatauki in Tainui waka, and it's ko tō manawa, ko tōku manawa, ka whakairia. So your breath, my breath, together go forth. And they were very keen that we captured both the intergenerational and the collective dimensions of privacy right from the outset in our visual representation. So there's a little statement that sits underneath it, and I'll just read it out. I know you can all read, but I'll read it out as well. Privacy regulations focus on individual privacy rights, leaving groups few options for protection. Extractive and unethical data practices result in harm to individuals and groups, and undermine fundamental rights to human dignity and self-determination. In Aotearoa, Māori are disproportionately classified and profiled in ways that discriminate and stigmatise. The Māori Data Privacy Framework draws on kawa and tikanga to guide decision-making about data privacy so as to protect Māori communities, safeguard Māori data, and restore Māori authority over Māori data. So there's quite a lot that sits in the Māori Data Privacy Framework. We don't have time today to go through all the bits and bobs, but I'll just talk about the key concepts, the key pillars that underpins it, and briefly what they mean. So there is no word for privacy in te reo Māori, but there are well-defined cultural protocols or tikanga that are central to a Māori concept of privacy that operate together to bring balance and order and provide guidance when transgressed. Professor Kylie Quince has written at length about Māori concepts of privacy and tikanga, so I would urge you to read her work if you have the time. I won't have time to go into that today. These are the visual, this is like a visual of the core elements without all the detail that sits underneath it. And we begin with our atua, rangi nui, at the top, and papatua nuku. And they provide the sanctity, protect the sanctity of our natural, social and material worlds. Atua are our foundation. They provide an enduring narrative of good spirit and connection and identity for current and future generations. And atua, they remind us that data and data technologies are human creations, and that entails responsibilities and accountabilities. Whakapapa sits at the centre of the framework. This refers to the genealogical layering and sequencing of relationships of all living things, from our founding ancestors to our digital versions of ourselves and our mokopuna. Data, they're literally our relations. All data comes from somewhere or someone, and all individuals are part of a collective, whether they know it or not, and the collective is always greater than the sum of its parts. So we have 4 tikanga values that form the pillars of Māori data privacy. The first one is mana, and to hold mana is to hold binding authority or power over one's domain, including digital domains, and mana can be held by individuals and groups. So for Māori, having mana in a digital environment means that we should be the ones that are able to make decisions about how our personal and collective information is collected, stored, accessed, deleted, shared, used, including secondary users. The full framework has a bunch of directives that are the bullet points that sit underneath it, and then underneath those bullet points there's entire sections about them. Again, we don't have time to go into all the detail today. I just wanted to share some of the high-level elements about what the framework actually includes. This is a quote from one of our mātanga that was involved in the project, and just speaking about his perspective on mana, and saying that it's inherently collective, and of course there's personal mana, but that comes with the mana of the group. So it's not only the personal mana, and that doesn't make sense. That's not pono, that's just mana munching. So in other words, we need to take account of collective dimensions of privacy because it's so important in Te Ao Māori. The second pillar is tapu, and tapu, of course, is an essential element of a Māori privacy concept. Tapu defines what's special or restricted. In the context of data, it safeguards and upholds issues of data restrictions and sensitivity. And this means that data that comes from Māori individuals or groups may still require restrictions in terms of how it is shared and used, even if it is de-identified. And it means that we should have the right to know if our data are being used to develop or train machines or algorithms, and the right to opt out. And of course, genealogical and genetic data are considered tapu and have long been an area of concern for Māori. And these concerns have been amplified by the proliferation of ancestry websites, direct-to-consumer genetic testing, the use of forensic investigative genetic genealogies by law enforcement agencies, and the deployment of biometric technologies. The Privacy Commissioner has recognised that Māori have significant concerns in areas including, for example, biometrics, and we'll return to that a little bit later. The third tikanga principle that underpins the Māori data privacy framework is mauri, and mauri is the force of all life, and it requires privacy law and standards that protect Māori data as a taonga, a precious resource of tangible and intangible value. And we've got a number of sections in that mauri tikanga principle. Don't have time to go into that here, but you can see here from the bullet points the sorts of things that are covered by mauri in the framework. And here we have a quote from one of our kaumātua, ki o tātou whakaro, mena he mauri tō te data kei te ora te data. So the data has mauri, and that must be respected and cared for. The final one is hou, and that's the vital essence of life that is shared by all living things. And in digital worlds, hou symbolises a state of balance based on a moral code of reciprocity, and it requires privacy laws and standards that protect the qualities of equity and justice, that uphold respectful relationships, and enable a wide range of options for redress when data breaches harm Māori, including tikanga-based options. So, in developing the framework, the guidance of our kahu kaumātua has been really critical. And we were always reminded that their hope is for a privacy paradigm that really protects the digital lives of all of their mokopuna now and to come in the future, and a privacy paradigm that is grounded in a much more holistic and relational practice of informational self-determination than a narrow focus on individuals. And they were very clear about that. So, second part, biometrics. This is a brief one. We've got various talks that will be happening throughout the webinar series on biometrics. I didn't catch the opening talk this morning from the Privacy Commissioner, Michael Webster, and Deputy Privacy Commissioner, Liz McPherson, but I know they would have talked about biometrics there as well. There has been a lot of Māori response to the consultation on OPC's proposed code to cover the processing of biometric data. There's been a lot of concerns have been expressed, particularly around, for example, FRT and the pilot that has been trialled in 25 of foodstuff supermarkets, well-publicised cases of misidentification involving a wahine Māori. And I sort of talked through some of our research team has made a number of submissions over the years around biometrics, and I talked through some of these or discussed some of these issues in a recent paper that was published, open access in Science magazine. If you just Googled protecting pieces of our science, that will come up and you can read it. It's like 1,000 words, so it's not a hard read. And it sort of steps through, the wider context of biometrics, the very patchy regulation in a global context, the sort of opportunity we have here in Aotearoa to do things differently, particularly we have, Section 21C in the Privacy Act, which requires the Commissioner to take account of cultural perspectives in regulating privacy. Having looked at different jurisdictions around the world, I haven't found any other jurisdiction which requires the privacy regulator to take account of cultural perspectives. So it's a huge opportunity here in Aotearoa. One that I think is largely untested. There's a lot of scope for improvement there. And, so in talking about the biometrics process, I do make the point that while there was good intent from the start to take seriously Māori concerns around biometrics, that the proposed draft code has largely been watered down, and cultural perspectives, servicing more on guidance rather than sort of black letter law, and that some of the safeguards that we might like to have seen are not very visible in the draft code. And some of those criticisms were also, I think, productive and fair ones. And these are the sort of robust debates that we should have. We're picked up by one of the biometrics industry magazines, and that appeared there. So they're both there, and I'm just giving you a screenshot. You can read them in your own time, but I think suffice to say that there are a lot of concerns around biometrics, but also some opportunity to do things differently. I'm mindful we need to get on to Jessie, so I'm just going to wind it up, Jessie. So the third piece is really around, okay, so we've done the research on Māori perspectives on data privacy. We have a framework to guide us about what the expectations are there. We know that there's some large gaps, but we also know that there's an opportunity through Section 21C around cultural perspectives. What might be some of the solutions moving forward? And also recognizing that on the ground, communities and innovators are already doing their own thing. They're not asking for permissions. They're already doing things in their own way to try and protect the data or the information that they currently steward, and that's amazing. But it's sort of like an end-to-end approach. We also need privacy regulations that genuinely reflects our needs as well. So one of the things that we looked at, and I'm acknowledging here as well, one of our research team members, Dr. David Watts, who was a former Privacy Commissioner in Victoria, who also worked on this paper, was looking at what is the opportunity for Māori data privacy code of practice under the Privacy Act that might be able to at least offer a partial solution for certain kinds of Māori data that's particularly sensitive or particularly valuable. What are the opportunities there to do something different? So as some of you will know, under the Privacy Act, the Commissioner has the powers to issue a code of practice, and of course it's going through that process at the moment with biometrics. And a code can provide additional protections for higher risk categories of personal information or privacy intrusive activities. And the Commissioner may develop special rules for particular categories of information privacy risks. A code can modify the operation of the Privacy Act and the information privacy principles, and of course it becomes part of the law. And the Commission is required to take account of certain matters when exercising a statutory power, including cultural perspectives on privacy. And for Māori, that of course is tikanga. So could there be an opportunity for a Māori data privacy code? We think there is an opportunity. We know there's a lot of work involved, and that's why we have an Office of the Privacy Commissioner, and they've been working hard on the biometrics processing code. But there's also potential here in the future for a Māori data privacy code. Now, this code could provide a higher level of protection over categories of information that are regarded as tapu. Currently, or in the past, where tikanga has been specified in legislation, it has been to make a requirement or provision for tikanga values and practices. A Māori data code could require that the collection, use, disclosure, security, and handling of specific classes of Māori data be consistent with tikanga, rather than prescribe very rigidly what that tikanga is in the actual code. So what would a code do? It could restrict the purposes for which these classes of Māori information can be collected, disclosed, used, and shared, including the secondary uses. It could put stronger requirements on agencies to demonstrate that their collection and use of these classes of Māori information is justified. It could require free, prior, and informed consent. The Act is, of course, focused on lawful purpose, not consent. But FPIC is really important for Māori, as it is with other Indigenous communities, as guaranteed under the UN Declaration on the Rights of Indigenous Peoples. And it would require greater transparency and independent oversight from Māori beyond a sort of like a sort of an advisory panel, for example. So we think that there's three classes of Māori data that would require additional protection. One of these is whakapapa data, which would include DNA, genealogical information, some class biometrics data, data about the deceased, because mana does not end in death, and aggregated information from personal data that's used for group profiling. And I just want to finish by saying a little bit about genealogical data or whakapapa data, and I know that Jesse's going to touch on this in his kōrero too. So, genealogical information is obviously far more the human ancestry, but the Privacy Act only covers the protection of our personal data of identifiable individuals. For Māori, of course, whakapapa data is considered a taonga, and we've already talked about what a taonga actually means. And why would genetic and genealogy and whakapapa data be so important? Because they literally define our collective identities and who we are as a people. Our research suggests that the prevailing privacy approaches are really poorly placed to provide adequate protection for Māori genealogical data, in part because they're applying an individualistic lens to data that are inherently collective. So there's both personal and collective dimensions to it. But we need that collective protection. Of course, we all know about 23andMe and the recent bankruptcy filing and the uncertainty about what's going to happen to that information that, sure, individuals may have consented to share, but it also encoded in their information and their records is a whole lot of information about their relatives who never consented for that information to be shared or used again and again and again for purposes that it may not even be aware of. So, there's a whole lot of tricky issues there, and the boundaries between what is personal data, what is collective data are becoming increasingly blurred. So, we need a more expansive way of thinking about this, and particularly for Māori, whakapapa data provides a really concrete example of where we need to try and figure out where these boundaries lie. So, individual consent is a shaky foundation for sharing information about others, and the impact of data misuse can radiate out to impact those who never consented to participate. It also enables companies to profit from collective information that they should not own. There's another example, the use of DNA in criminal investigations. So familial DNA searching has been used in law enforcement agencies in various jurisdictions to search DNA databanks. And of course, high-profile cases have led to the use of public genetic genealogy databases to identify offenders. Here in Aotearoa, police and ESR were using forensic genetic genealogy tools as a pilot to try and solve cold cases. I'm not sure what the current status is. But to my knowledge, there was never any consultation with Māori about the use of those tools, even though the concerns of our Māori communities were well publicised. In 2016, the Law Commission began a comprehensive review of the legislation governing the use of DNA in investigating crime. The Māori Data Sovereignty Network made a submission in it, and I'll quote, "Familial searching raises particular issues in relation to the balance of individual and collective rights. Given the disproportionate taking of biological samples for Māori and the disproportionate inclusion of Māori in the forensic databanks and the relatively small size of the Māori population, familial searching would have differential impacts on Māori communities and individuals." It also noted that Indigenous peoples around the world have raised specific concerns about genetic samples and genetic data for many years, including unethical practices, and argued that any legislation that deals with samples or DNA from Māori must include Māori rights to govern the samples collected and the data generated from them as well. So, the expansion of new technologies gives rise, every year, every month to new issues, but at the heart of them are these sort of underlying same concerns. The most recent manifestation, of course, is FRT, particularly in the context of the revival of moko kauai and mata ora, which is a form of whakapapa data and which is highly tapu, and what happens to that information when it's captured for sort of broad-based surveillance technology. So, in all of these examples, there's fundamental and deeply embedded power imbalances. An individual consent does not get us anywhere close enough to rebalancing them. So I think I'll leave it there, Jessie, and ka tuku te rākau ki a koe, and I will stop sharing my screen. Kia ora.
Kia ora, ngā mihi ki a koe Tahu o tō kōrero ki te kaupapa o te Māori data privacy. Tēnā koutou katoa ki ngā tangata e hui hui mai nei, ki tēnei kōrero. I uri tēnei no Ngāti Parau, no Ngāti Kauwhata, ko Jessie Haratua Porta tōku ingoa. Bear with me just a moment while I get my slides up, and the facilitators have just nudged me to say, if you do have any questions, just pop them into the Q&A section, as we're not able to see the sort of raised hands while we're presenting, and we'll have a look at those questions at the end. There might be some Tahu can answer in the chat while I'm presenting, but we will have a bit of time at the end, so bear with me. Excellent, I think I got myself up there. Oh, so I'm Jessie Porter. I've been a privacy advisor at Oranga Tamariki for probably about 5.5 years now, which is fairly safe to say it's a unique and really challenging environment to practice privacy for a number of reasons. It's an environment where privacy is particularly nuanced. We've still got those same broader considerations, ensuring information is stored securely and that sort of a thing. But there's also a strong expectation that collection, use and disclosure of personal information will be more liberal to ensure that tamariki are safe and supported. So my team has a strong focus on how to share information safely and appropriately, including under legislation other than the Privacy Act, because good privacy practices ultimately help people to share even very sensitive personal information safely and with confidence. Just a wee disclaimer here, I don't expect that there's anything too controversial in my presentation, but all the same, all views and opinions expressed are purely my own and don't necessarily reflect the views and opinions of Oranga Tamariki. And I've had the privilege of reviewing Tahu's paper on that possibility of a Māori data code, what it might look like, what concrete issues it might address. And it was a really interesting experience as someone who's often been asked to, put a Māori lens across privacy in the operational space. And as Tahu has sort of spoken to, it's not an inherently Māori concept and certainly not the idea of individual privacy. So that's quite a broad sort of challenge to lay down. And then also in the context of my work with iwi Māori partners around information sharing, getting them the information that they need to carry out, deliver services to their people. And it also got me reflecting back in turn on some of the ways that our current Privacy Act, although as Tahu mentioned, there's certainly room for improvement there, can and it does, at times does already enable and support collective ways of working, including the prioritisation of the collective good where appropriate, even without necessarily needing a collective definition of privacy or of personal information. So Tahu's already covered some really good ground on what we mean by collective privacy more broadly. So I'll just cover this briefly to set the scene for the rest of my presentation. So although our privacy law in Aotearoa, New Zealand defines personal information explicitly as relating to individuals, it does recognise that information about an individual isn't always separable from information about other individuals. For example, by providing withholding grounds for an agency to refuse access to one person's personal information, if its disclosure would mean the unwarranted disclosure of the affairs of another individual. Tahu's earlier example of that genetic testing company, 23andMe, who filed for bankruptcy at the end of March just this year, is a really good case study for demonstrating how individual privacy can be a collective concern as she went over there. And a federal judge in the US has ruled that 23andMe can sell their consumer data as part of their bankruptcy proceedings. And unsurprisingly, health and life insurance companies have already shown quite a bit of interest in obtaining that information. And here in Aotearoa, identifiable health information is covered by the Health Information Privacy Code, which recognises the heightened sensitivity of that class of information and places additional restrictions on its use and disclosure above and beyond what's in the Privacy Act. But even that Health Information Privacy Code excludes agencies from that requirement to obtain your authorisation before they disclose your health information if they are selling their business and consider it undesirable or just impractical to obtain that authorisation from you. So we could see similar situations occurring here in Aotearoa. As I say, though, collective privacy isn't in itself my specific focus today. So I'm going to be looking at some of the ways that the Privacy Act is currently equipped, to a degree, to consider cultural values as well as enable collective ways of working and that prioritisation of the collective good over individual privacy rights where appropriate. So the Privacy Act also recognises that there are times the collective good outweighs the rights of the individual. One of the more commonly known examples is that the Privacy Act authorises an agency to use or disclose personal information when it's necessary to prevent or lessen a serious threat to public health or public safety. And we see the same considerations in other relevant legislation. For example, the Health Act includes several contexts that require the disclosure of sensitive health information about an individual in the interests of the wider public health and safety. And ultimately, every culture and every community has to balance individual and collective rights, risks, and benefits, even though every culture and every community is going to balance them differently. And even our Privacy Act, which is focused on individual privacy rights, recognises the importance of cultural perspectives by stating, as Tahu mentioned, that the Privacy Commissioner must, when carrying out their statutory role, take account of cultural perspectives on privacy. And as an example of this in practice, I dare say a lot of you are going to be familiar with the 2021 High Court reviews into the Ministry of Health's refusal to provide COVID-19 vaccination information to Te Poumatakana, the Te Whānau Ora Commissioning Agency. Very briefly, just for those of you who aren't familiar, Te Poumatakana asked the Ministry of Health for relevant information about unvaccinated Māori, so that whānau ora partners could reach out to try and improve vaccination rates, which were lower for Māori than for the population as a whole. So that broader health and safety considerations there, as well as for Māori themselves. And I understand that the Ministry of Health did offer reasonably fine-tuned anonymised mapping data, but declined to provide individually identifiable information such as names and contact details. Just to make sure a quick drink. Now, Te Poumatakana successfully challenged that decision in the High Court. The Ministry of Health reviewed and actually reaffirmed its initial decision not to provide the information. Te Poumatakana made a second successful challenge through the High Court again, and the Ministry of Health did eventually release the information with certain conditions, such as requiring that the information be securely deleted by the recipients by a specific date. Now, the High Court decision was based on the Ministry having not involved the applicants, Te Poumatakana, in the wider consultation process with iwi, undermining their natural justice right to be heard, and that there had been inconsistent treatment based on the disclosure of the same personal information to other entities, in particular non-kaupapa Māori health entities, without iwi consultation, consent, or necessarily even their knowledge that that information was being shared in that way. And then a later aspect of inconsistent treatment was the lack of similar consultation with iwi before the Ministry of Health provided, again, that same information to whānau order providers for the related purpose of caring for Māori who were self-isolating with COVID-19. And the Privacy Commissioner made a submission to the High Court proceeding with two views. One on the interpretation and application of one of the disclosure provisions under that Health Information Privacy Code that I mentioned. And the other one on the wider context of use and protection of individuals' health information, including, amongst a number of other things that you see there on screen, in light of obligations under the treaty. And you can read more about that particular submission on the OPC's website. What's also interesting in this case, though, is that the OPC, the High Court, and the Ministry of Health all factored Te Tiriti and tikanga obligations into their assessments and decisions regarding the application of the Privacy Act to this particular case, along with the other considerations on the OPC's list there. And what it shows is how these balances between individual and collective rights, risks and benefits is often not clear-cut or straightforward, and every community, every culture will have competing views and interests and opinions contained within it. Ultimately, though, the High Court decision here confirmed that it was appropriate to incorporate cultural values into an assessment of the balance of individual privacy rights against the greater good. It simply disagreed on the conclusion that the Ministry of Health had reached and ruled more strongly on the side of the collective good. My second example is an Oranga Tamariki function called Family Group Conferences, or FGCs for short, which are another example of how privacy legislation can enable collective ways of working. So an FGC is a structured meeting where the extended whānau, friends, and other professionals and people in the life of a particular tamaiti or rangatahi come together to make decisions as a group and establish a plan for support. FGCs occur in both the care and protection and youth justice spaces, and in that youth justice space in particular, they often also involve victims as direct participants. And at these meetings, the broad expectation, supported by the legislation as seen here on my slide, is that all relevant information will be shared with all participants, including often very sensitive personal information, because it's largely counterproductive to ask people to make a decision as a group if they can't base their decisions on that same information. And I'll just pause here for a quick explanation. Although FGCs are enabled under the Oranga Tamariki Act rather than the Privacy Act, in my professional opinion, the purposes for use and disclosure of information under the Oranga Tamariki Act are already technically authorised by the Privacy Act. So the Oranga Tamariki Act lays out grounds for information sharing that apply exclusively to people working in the child welfare and protection sector. And they're written in much plainer and directly contextual language, which provides important clarity for social workers and others who are going to need to apply them in often very complex, very challenging and time-pressured practice environments where they don't need to be kind of trying to interpret legalese language and apply it to their situation. That said, though, many of those purposes for sharing personal information under the Oranga Tamariki Act fall under preventing or lessening a serious threat to the life or health of an individual or to public health and safety, and for using and disclosing personal information for the purposes for which it was collected. At other times, it will be done with the authorisation of the person the information is about, or other grounds that are, again, already permissible under the Privacy Act. And one of the purposes for which Oranga Tamariki collects personal information is to share it with multiple parties in group settings such as FGCs, so that those people can use it to make collective decisions about what is in the best interests of a particular Te Māori o rangatahi, their family or whānau, and their wider communities. So if the Oranga Tamariki information sharing provisions didn't exist, this FGC process and processes like it could still have been established under the Privacy Act. And so in this way, FGCs are a good example of how processes that enable collective ways of working, collective decision-making, and consideration of the collective good can be achieved at least to some degree under the Privacy Act. And to wrap up, I'd just like to talk about the benefit, collective and otherwise, of good information sharing agreements. So to be clear, these agreements are distinct from what are called approved information sharing agreements, also known as ACEs, which are a legislative instrument that authorise specific context for information sharing that would not otherwise be permitted by law. ACEs can only be implemented for the delivery of public services and must have a government agency as a lead agency. An information sharing agreement is a looser term and it doesn't apply only to the public sector. It could be a standalone agreement between agencies or included under a broader contract, memorandum of understanding, outcomes agreement, service level specification, whatever you're calling the primary document outlining the arrangement between your agency and another. And if done right, an information sharing agreement will explicitly state the purpose for sharing the information, including the legislative authority for sharing, and any other restrictions or considerations that may apply to its handling. And these may include tikanga and other cultural considerations. So being familiar with privacy and information sharing mechanisms like information sharing agreements is important to ensure that personal information can and is shared where appropriate, including at times for purposes involving collective use of personal information or where the collective good may outweigh considerations of individual privacy rights. So that wraps up my kōrero on some of the ways in which our current legislation enables and supports, as I say, the consideration of cultural perspectives, cultural ways of working, and prioritisation of the collective good over individual rights where appropriate. And that's both through the direct interpretation and application of the Privacy Act and supporting processes and documents such as good information sharing agreements. So thank you all for coming to listen to us today. I think our count's gone up over 400 people. So kia ora koutou, and I will hand us back to Tahu now to close off our session. Thank you all.
Oh, kia ora, Jessie. Well, ngā mihi nui nui ki a koutou. Mō taringa, mō koutou taringa. Kia hiahi nei. I'm thankfully quite surprised that we have like 400 people that have turned up to our webinar. But it's great because it shows the degree of interest in this kaupapa, which we thought there would be a high degree of interest, but perhaps not 400 people. But we've been furiously trying to answer speed typing in the Q&A window, and I think in a few places I may have put the wrong, because it's going so fast, I may have put the wrong answer in the wrong window, so apologies for that. But I do wonder, Jessie, if we can have a stab at maybe just answering a few questions. We've only got 10 minutes left, but a few questions before we go. And I do see that there's one here which I think you would be good to answer. Is there any difference in information sharing agreements and data sharing agreements? And I know you're talking about that a bit in your kōrero.
Oh, yeah. Yep, that's a good question. So that's from someone, Lee. So loosely speaking, because these terms are all sort of quite loose, but we tend to say information sharing agreement if it involves personal information, data sharing agreement if it doesn't. So if it's aggregate data, if it's stats, that sort of a thing. Long story short, you need less, you don't need a legislative authority generally for sharing the, non-identifiable data. There's less security considerations and things like that. So real rule of thumb, that's the difference. Information sharing is if it's personal information. Data sharing is if it's not non-identifiable info. Quick question there. How would an organisation use the Privacy Act not to release personal information to a person when they're trying to protect another person? There's withholding grounds. I forget exactly which section of the Act it is, but it goes into quite a bit of detail about the grounds for refusal under IPP6, and that includes safety grounds or when it's just not in someone's best interests.
I think there's also another one related to Oranga Tamariki, the grounds for the
Oh,
disclosure, right down the bottom from Karen.
That's a good question, Karen. I'm sure I've seen that document, but it's just not front of mind for me at the moment. But if it's a decent disclosure statement, then yes, most likely. We are actually working on updating our disclosure statements at the moment, both for internal staff, for providers and things like that, but they do tend to be very good to have, yeah.
Yeah, a couple of questions about the academic that I referred to, who's done a lot of the foundational work on Māori concepts of privacy. That's Kylie Quince. I think other people have put that in there. Now, this may not relate to personal data privacy, but I'll throw it out there. How should the public?
Interesting question.
Yeah, no, it is. And we we've talked about this with our kaumātua and our kahui with our kahui, because of course, with whakapapa at the centre, that recognises layers of relationships, not just human relationships, but all our relationships and responsibilities to our non-human relations. And can te taiao have a right to privacy? Once te taiao has a legal personality, can te taiao have a right to privacy? So what happens though is if you're trying to effect change within a regulatory framework, and the regulatory framework is narrow, a lot of the stuff that our communities, and kaimahi are interested in gets defined as out of scope, because it's not personal data and it's not human data. Now, the Māori data privacy framework that we've been working on, it's gone through a bunch of iterations with the mana tapu mauri hau. When we started off with that, we did start off from a very broad scope, and including privacy, not just of humans, but of places as well. But we found it became a little bit unworkable, and we wanted it to have impact in a particular area. And so our Māori data privacy framework is not particularly well positioned to speak to some of the issues that you're talking around about the sharing of white shark DNA. I wrote I'm sorry for sounding like I'm self-promoting, but it's just a quick way to look at stuff. But Amanda Black, who's a co-director of one of the other centres of research excellence around biodiversity, but she and I wrote a paper in Science, so you can Google it, in Science magazine, and that was on Māori data sovereignty in relation to non-human genomic data. So it's a little bit broader than privacy, but Paul, there may be some whakaaro in that science piece that might be interesting to you when you're talking about the white shark DNA, because we do talk about that directly, particularly around the moa. We use the moa example as our sort of entry point. So hopefully you'll find that useful. Gee, that was a long-winded answer. We're at 12:54. Were there any more? Could you see any other ones there, GC?
Let's have a look. We've got most of them. Hang on. I'm looking at the ones you've already answered, so that doesn't help.
Horrified at how our DNA has been shared internationally. Tika Tahu, Stephanie. Me too. And I think it's encouraging that we see some of our communities developing their own technologies to at least try and protect their whakapapa information in their own realm. I know I did share a link there to some of the mahi we've been doing with our little hapu that doesn't have a lot of money, but we have, kaimahi and whānau who are interested in this kaupapa Ngāti Tipa. So we have done 3 briefs, like 4 to 6 pages around hapu data sovereignty, data privacy, and most of our mahi has been focused on whakapapa data. So we've been developing sort of tools and processes and to some extent some infrastructure where we can try and protect our whakapapa information. But the best line of defense is really, because we want to benefit from it as well, right? It's not just about locking it away. Like our whānau want to have access to it, but they want to have access to it in a way that is tika, and then where they can protect it for future generations. So we put a lot of, as a hapu, a lot of effort into as well, sort of trying to build our whānau capacity and capability for being awesome stewards of our whakapapa data as well. So, and I really believe that that's the way forward, even though it would be good to get changes in the Privacy Act and a code. We don't have a rōpū per se. There is a Māori Data Sovereignty Network, Te Mana Raranga, and you can join that through their website, which is kind of like a broad network for all manner of Māori data related kaupapa, including privacy, and lots of other things as well. So that's probably a good first step.
Potentially, if you're interested, joining groups like the Privacy Foundation, who don't have kaupapa Māori yet, but that's kind of because we need that critical mass of sort of subject you're interested in. The more members that we get bringing that up, then, that'll be one way to bring those people together. And
where would they find that? Is there a URL for that, Jessie? Is that the rōpū that you're involved in?
Yeah, it's just a sort of casual, it's got academics, it's got practitioners. I think if you just do a Google search for Privacy Foundation New Zealand, you'll find it. I'm sort of just a member essentially, but.
Okay. Well, I think we might be running out of time, Jessie. So
great question for me though.
Yeah, great questions. My mind is sort of boggling. And just to mihi to you all for taking the time out of your very busy days to join us on this kaupapa, and we hope that it was of some value to you. Will be made available, I understand, via the OPC website or the YouTube channel. And I think should I close us off, Jessie, with a karakia hei whakakapi? Ka pai.
Good, thank you.
Well, me karakia tātou. Tēnei te whatu kei au, te whatu kei a tātou. Ko te whatu o te Māori ora, ko te whatu o te Māori roa. Ko te whatu o te pūkenga, ko te whatu o te wānanga, ko te whatu o runga, ko te whatu o raro, ko te whatu o te ara ki mua, haumie, huie, tae ki e. Ai, hikuna.